Very, very disappointing and disturbing ruling. What we have today is 5 male justices ruling that essentially discrimination against female workers is not discrimination at all. They claim it's a narrow ruling. That makes it even more disturbing because what they're saying is they're protecting other people's rights, but not women, from having our bosses reach into our bedroom. I think it's very disturbing. I think it sets a precedent that could affect all Americans, and I think everyone should wake up and smell the coffee.
Today we applaud the Supreme Court for upholding our basic religious freedoms and rights to practice our faith and live out our beliefs without fear of government punishment and retribution.
The Supreme Court has spoken. Hobby Lobby and its supporters have won big against Obamacare. But is the decision truly a good thing for people of faith? Was it more than the letter of the law behind these decisions? And then what of a president who has decided he will go it alone, come hell, high water, or a lawsuit? This and more on the legal docket. Let's welcome into Midpoint former law clerk to Justice Thurgood Marshall and Harvard Law Professor Mark Tushnet joins us. Professor, thank you so much for being with us.
Thanks for having me.
Professor, let's get right to it when it comes down to just this one issue against Hobby Lobby. Looking at it from a legal perspective from the outside, what's your first take?
Reading the opinion from the outside, it looks like a rather limited opinion that won't substantially interfere with the overall operation of the Affordable Care Act, or even probably limit the access of employees of places like Hobby Lobby to the kinds of contraceptives that Hobby Lobby objects to.
All right, then let's take that for one moment, and I want to play a soundbite here from Elise Hogue. She is the president of the Pro-Choice America group, and this was her immediate reaction right after the decision came down.
This is a great day for the political left and the political right, because no matter what administration is in power, our religious freedom cannot be violated.
Professor, the thing that caught a lot of people is the court has always said that they don't want to get involved in religion, yet now are they putting themselves smack dab in the middle of religion no matter what they did in the first place?
Well, that's a good question. The problem, if there is one, is that Congress told them to get involved in the Religious Freedom Restoration Act. That statute was a reaction to a Supreme Court decision that said, in effect, we're not very good at evaluating the credibility or the sincerity of religious beliefs, and we'd like to get out of it. And they did on their own, but Congress came back in a couple of years later and said, no, sorry, we want you to make these decisions.
In your opinion then, looking at this, and we've had a number of people who have commented saying that this is really very narrow. It's not as broad as some people are making this out to be. Can you put that into better perspective?
The answer to that question is, unfortunately, maybe it's broad, maybe it's narrow. We don't know, and we won't know until lower courts and eventually the Supreme Court deal with follow-up cases. Justice Alito's opinion does contain a lot of qualifying language. It says we're dealing only with contraception, not with blood transfusions or vaccinations. It says we're dealing only with a closely held family corporation, not with a publicly held corporation. And all of that is right. But it's also true that the legal analysis that he offers is something that people with religious objections to vaccination might be able to use effectively, and that large, not family-owned corporations might be able to use effectively. We just don't know from the opinion.
Would it be your opinion then that as the lower courts start to get a hold of not only this decision but the others that we have seen in this Supreme Court run here in 2014, that quite frankly the people who are celebrating or who are bemoaning the fact of what happened here, it's really sort of premature because we're going to see these things sort of hashed out and looked at now for what, 3, 4, 5, 10 years down the road, maybe more?
I'd say 2 or 3 years before we actually know what the contours of the decisions and its effect are going to be. I think there's an immediate thing, which is, and this is tied to one of the topics I think you may want to talk about, the Department of Health and Human Services probably is already working on a new regulation of a sort that Justice Alito described in his opinion, and it will promulgate that regulation, which would provide access to these contraceptives in a different kind of way. And then there'll be more litigation about that. So that new regulation, which my guess is will come online in a few months, will produce lawsuits that'll get decided in a year or two.
When you talk about that, and it's marvelous how sometimes great minds think alike, we're moving right along the lines of health and human services here. When you talk about those new regulations, again, from that legal standpoint, what would you see as being the meat of it here, and what that language will be and what they're going to go after?
Well, it would be adopted from a provision that's already in place dealing with religious nonprofit organizations like churches and church gymnasiums and things like that. There, the regulation says, look, if you basically tell us that you have a religious objection to providing these services or insurance for these services, if you just tell us that, we will go tell your insurance company that it has to provide the services at its own cost, no cost to you and no cost to your employees. That's a provision that's in effect already with respect to other organizations, and I guess it would be put in place. My guess is it'll be put in place for organizations like Hobby Lobby.
Let's discuss Obamacare here, because there are many people who say that this was, and I'm sure you've read them, we all have, this was a defeat for Obamacare, a sound and resounding defeat. There are others who will say, wait a minute, it's just not so. It's not nearly as critical as some people believe. Where's the fact in here?
This is a small incursion on the overall scope of the Affordable Care Act. It's not a major blow. It'll be relatively easy for the administration through regulations to work around. There are more important, more serious challenges pending to the overall Affordable Care Act, pending in the lower courts. This one attracted a lot of attention, partly because of its religious context, partly because it involves contraception, but it's not really a major feature in the Affordable Care Act.
Professor, I'm going to move off the Supreme Court here to a couple of other legal things here in the couple of minutes that we have left. Executive action is something that a lot of people are talking about right now, whether or not the President of the United States has the right to issue as many executive actions as he has. Of course, the Supreme Court, I got to go back to them again here for a moment, just slapped him down last week on one of his decisions. And this is the American public now who is asking, is what he is doing now in doing things unilaterally completely legal?
Unfortunately, the answer to that question is it might be.
Okay, well, it's good. It's good to cut that. Why is it might be? Why isn't there a clear? I'm sorry, I didn't mean to interrupt, but no. People are going to ask, why is it not clear?
Because lots of the things he's doing are embedded in federal statutes that Congress has enacted. And in those statutes, in many of those statutes, there are provisions that say the president can waive these provisions or can adopt regulations consistent with them. And you'd have to ask, with respect to specific things that he's done, whether it is authorized by the statutes that Congress has enacted. And the answer to that is actually, I think, in most of the cases, it's pretty clear that he is authorized by the statutes to do what he's done. In some of the cases, it's a more touchy or tricky legal question. But you have to look at it statute by statute and not talk about the overall executive authority. What he's exercising is mostly powers that Congress has told him he has.
I'm so glad I'm not a lawyer. I just play one on TV. 15 seconds left, the John Boehner lawsuit. Any meat whatsoever here at all?
Basically, no. By the time it gets decided, the President Obama will no longer be president.
So it'll make for a wonderful PR moment right here, and just go ahead and galvanize the base more than anything else.
I think that's probably right.
There you go. Professor Mark Tushnet, thank you so much for coming on board and making some sense of everything that's here. I promise you, I will never attempt to be a lawyer. I will always ask you first before I try to make any kind of conclusions here.
Okay, thank you.
So good. Thank you so much,
Have
Professor.
a good
It's true, too. I mean, if you think about it, all the lawyers that we talk to, there are those who are giving us different opinions, but they're basically saying the same thing. He's got the right in some cases. That's a little scary to some people. Coming up next, the latest from America's Forum and the Steve Malzberg Show. What did you miss? Don't worry about it. We'll fill you in right here on the Newsmax TV network and on Midpoint, where every day we question everything.